Put down your vapes, put down your pens, set aside your bag of edibles. We're going to go old school today and talk about drinking and some of the perils and some of the consequences that can befall people when they serve minors at house parties, or if people are overserved at bars or restaurants as paying customers. So the first thing I want to address is while I know things like pens and vapes and marijuana is much more in vogue these days, and there's actually been some reports I've read that alcohol use amongst younger people is actually down considerably. It's still something that requires attention, and it's still something that my practice comes across with some regularity. So the first thing we'll talk about is what's generally referred to as the social host law. It's codified in the General Obligations Law of the State of New York, Section 11-100. And that specifically concerns people under the age of 21 being provided alcohol at places like at house parties, or maybe even, say, college parties, fraternity parties, etc. It's important to note that there doesn't have to be a sale of alcohol to people under the age of 21 for this law to apply. It actually involves the provision of alcohol to anyone under the age of 21. Now, there's some other sections of law that create the legal framework that serve as the basis for these types of violations. We don't need to get into all those technicalities, but for anyone who's interested, alcohol beverage law, Section 65 is something that would kind of be referred to in these instances, but none of that really changes the bottom line of what I'm going to be discussing now. When someone is served and they shouldn't have been served, they're underage, and that underage drunk kid, will just say, to keep this discussion easy, hurts somebody, what happens? Obviously, the victim of that drunk kid has a claim. Sometimes it could be a drunk driver.